All right, let's make sure that our technology is working. Everyone hear me okay? Raise your hand if you can see and hear okay. All right. Mr. Money, I appreciate you slipping the jacket on. I've had some hearings earlier this week that I thought they were going to do that and they never did. Matter of fact, they just kind of unbuttoned the shirt even more and started relaxing even more. I had to hurry up and get finished with the hearing because I didn't know where we were going on. So,
well, Sean and I both read the story about a lawyer who got beat up for showing up in a t-shirt. So I don't want that to happen to me.
Yeah. You just want to read about that, right? Don't want to live, right? All right, let's get back to where we were. We are back on the record. And this is in cause number 20-7, Wanda Dixon John versus 21st Mortgage Corporation. And when we recessed, I believe, Mr. Monning, you had passed yourself to Mr. Brady. We had our discussion. So I had us about an hour. I moved my 3 o'clock, 4 o'clock. So it probably gives us about an hour because I'll need to get up before that next one. So if we can make use of our time and possibly conclude within the hour, I would appreciate it. So at this time, if there's no other housekeeping measures that we need to take up, then I'll allow you, Mr. Brady, to go ahead with your questioning of Mr. Monning.
Thank you, Your Honor. Mr. Monning, you're aware that there was a written arbitration agreement between your client and my client, correct?
Yes.
Okay. And Your Honor, I'm sorry, when I communicated with your coordinator, I just sent over exhibits and I did not pre-label them. I didn't know how the court wanted me to handle that. So I have referenced, some of my exhibits as being those that were attached to my motion for summary judgment. So I don't know if the court has that in front of.
Yeah, so my coordinator has taken the exhibits and I'm able to access them electronically. And I can see that however you name them, for instance, claimant's bench book, AAA, post arbitration brief dated. I see the entitlements of the documents, but I don't see any exhibit numbers. So however you want to offer them, I will record them that same way.
All right, thank you, Judge. Well, one of my emails to the court, I'll represent Your Honor, was that my client intended to rely upon exhibits that were attached to his motion for summary judgment. And that's what I was going to refer to. And so the court might have it in front of it. That would be, actually, Judge, the court, I think, put like a number in the upper left corner of my motion for summary judgment and the exhibits. It's 200 pages total. So that's what I was going to refer to. So the court might identify documents.
Okay. And are these exact exhibits in your motion for summary judgment? Are they the same one that you've emailed over to my coordinator?
Well, I said we intended to rely on exhibits attached to the motion, and I sent over some additional documents after that I'll also be referencing throughout.
Okay, so you also want, so you want me to refer to your motion for summary judgment exhibits?
Yes, Your Honor, if that's okay.
Yes, I'll need just a moment to pull up that system so that I can do that.
I think they begin on page 30. All right, Sean. Mr. Brady.
Oh, you can call me Sean. Your Honor, are you waiting for me?
No, you're waiting for me. I've got to open my CMS system, my case management system, and access this case in the pleadings. And then once I do that, that should enable me to see your motion for summary judgment and your exhibits attached there too.
Thank you, Your Honor.
And Mr. Brady, if you just want to offer all of those exhibits that are attached, that's fine with me.
Yeah, I don't know. I'll probably just take them individually like you did.
Okay, the court is now viewing the defendant's traditional and no evidence motions for summary judgment. And I believe that was filed May 15th. Is that the motion for summary judgment you're referencing?
Yes, Your Honor.
Okay, all right, I do have access to that.
Okay, and Mr. Monning, I want to direct you to what has the number 31 in the upper left-hand corner.
Yes, that's the arbitration agreement.
Okay, and Your Honor, I move to admit the arbitration agreement as 21st Mortgages Exhibit 1.
No objection.
All right, the court hereby admits Respondents Exhibit 31. Is that how you want it marked? Or Defendants Exhibit 31?
I had said Defendants Exhibit 1, but admittedly,
Okay.
there's not an exhibit sticker on there. However you want to do it, Judge.
Yeah, Defendants Exhibit 31 is admitted into evidence.
31.
31, yes, the arbitration agreement.
Okay, and Mr. Monning, do you see, I think in the third full paragraph where the sentence where it says the arbitration shall be conducted in accordance with the American Arbitration Association's commercial arbitration rules. Did I read that correctly?
Yes, I see that.
Okay, is that what it says?
That's what it says.
And Mr. Monty, have you ever researched the commercial arbitration rules?
Yes, I have.
Okay, and so you're familiar with what those rules provide for?
Mr. Brady, those rules change from time to time. Yes, I'm generally familiar with them. Yes.
Okay.
They don't apply to this arbitration, but
well, the arbitration agreement says that the commercial arbitration rules apply, correct?
yes, but the rules of the American Arbitration Association says that they don't. This is being administered under the Consumer Arbitration Rule.
Again, I'm to move this along. I'm just asking for a yes or no answer. And
The answer is no.
well, the arbitration agreement provides that the commercial arbitration rules of the American Arbitration Association will apply, correct?
That's what the agreement back in 2005 said.
Okay.
The consumer rules did not exist in 2005.
Mr. Prater, have you ever had the opportunity to review the rules of the American Arbitration Association concerning the qualification of its arbitrators?
Yes.
Okay, and where are those rules located? Do you know?
You go to a website called adr.org, and there's some reference to qualification of arbitrators.
Okay.
I think they may be primarily available only to the arbitrators themselves. The AAA, as I understand, has internal methods of qualifying its arbitrators.
Well, you are aware, though, there is a document available to the public that discusses the minimum qualifications to serve as a AAA arbitrator, correct?
I'm not aware of that, Mr. Brady. I would stand to be correct. I wouldn't be surprised.
All right, I'll pass the word, Sharon.
All right, anything further through your own testimony, Mr. Monning?
Yeah, the arbitration agreement, although it does call for arbitration under the commercial arbitration rules, there was litigation in the mid 2000s concerning the constitutionality of arbitration of consumer cases by the AAA and by another entity called the National Arbitration Forum. They lost. The arbitral bodies lost those cases. The National Arbitration Forum ceased to exist. The AAA chose to adopt new rules applicable to consumer arbitration. And those are the rules that are applied in this case. This arbitrator was appointed in accordance with the consumer arbitration rules, and it was administered in accordance with the consumer arbitration rules.
Anything further through your testimony?
No, Your
Any
Honor.
further? Okay, all right. Mr. Brady, any additional witnesses or testimony?
Yes, I would call Jeff Warkins with 21st Mortgage Corporation.
All right, Mr. Workins, and let me see if I can unmute you. You may have to unmute yourself. It's not allowing me to unmute you.
Okay.
All right, Mr. Workins, if you will, raise your right hand. I'm going to place you under oath. Mr. Workins, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, Mr. Brady.
Mr. Workins, you have seen the arbitration agreement that's now been admitted into evidence in this case, correct?
Correct.
And it does provide that the arbitration is to be conducted in accordance with the commercial arbitration rules of the American Arbitration Association, correct?
Correct.
Okay, and are you familiar with those rules?
Yes.
Okay, and do you know if those rules make reference to minimum qualifications for someone to serve as an arbitrator with the American Arbitration Association?
Yes, they do.
Your Honor, during the break, I had actually emailed to your court coordinator 2 additional exhibits that we are intending to rely upon as rebuttal evidence, as there's now been a challenge to the qualification of the arbitrator, and I was only provided exhibits that Mr. Monty intended to rely upon at 4:30 p.m. yesterday, and clearly have been able to see the direction that he's going to try to challenge this arbitrator. I think we should be permitted to, that I should be permitted to examine this witness about the rules that on its face the arbitration agreement say control.
And are you asking about whether or not an exhibit is going to be allowed?
Yeah, yes, Your Honor. I'm going to, well, I'll go ahead and I just wanted to make sure the court had those documents before it, because it's something that I emailed between between when we adjourned last time, Your Honor.
Let me show you what I have, and you can tell me if I'm moving in the correct direction. These are the exhibits that my coordinator said that you provided to her via email, and she has saved those in my shared drive. So I have access to these.
Well, I called your coordinator during the break, probably.
It's the last 2, Sean. It's the last 2. Yeah, he has them.
Okay, I'm sorry. I'm having I can't, it's so small I can't see it. I'm sorry on my end. Okay. Jeff, which one is the last one and which is the second to last one?
The second.
Yeah, let me answer, Mr. Workins, if you don't mind. The second.
Thank you, Your Honor.
The second to last one is entitled 838. Commercial Arbitration Rules.
Okay.
And then the last one is Qualification Criteria for Admittance to the AAA National Roster of Arbitrators.
Thank you, Your Honor. Mr. Workins, I'd like for you to take a look at the commercial arbitration rules, please.
Do I have those, Mr. Brady?
Yes, I copied you on my email to the court coordinator.
Judge, could you delete that screenshot? It's blocking my computer. I can't. There, now I can get to, you emailed them. When did you email those to me?
Oh, about 2:15, 2:20.
Maybe it's embedded in this one. Okay, I see it. Let me open them. Okay, I've got the commercial arbitration rules up.
Mr. Workins, is there any reference in the commercial arbitration rules to how an arbitrator is to be appointed?
Well, yes, there's the actual rules contain a national roster of arbitrators provision, and then there's accompanying qualification criteria on the website.
Okay. Your Honor, I would move to admit the commercial arbitration rules into evidence.
Objection irrelevant. This case was administered under the consumer arbitration rules.
And Your Honor, he's basing that objection upon some legal authority that I haven't even had the chance to review and that's never been cited before. But I think on the face of the arbitration agreement, it says that the commercial arbitration rules apply.
Well, let me, if you Give me a second. I'll go back and get the email from the AAA saying they will be under the consumer arbitration rules, but give me a minute here.
Well,
Mr. Brady, what number are you going to label that? You're offering that as defendants what?
well, there's no number on the document itself, Your Honor. So you want to just say 21st Mortgages Exhibit 2?
I'll say defendants exhibit 2.
Thank you, Your Honor.
So right now we have defendants 31, the arbitration agreement, and defendants exhibit 2. The court is going to admit defendants to overrule the applicant's objection. And then, Mr. Monning, understand that you may have an additional piece of evidence you want to offer by way of your email and the consumer rules. Go ahead, Mr.
Thank you. Mr. Warkins, take a look at Rule R3, please.
Okay.
What does that rule provide for, please?
The establishment and maintenance of a national roster of arbitrators provided in these rules.
Okay. And now, Mr. Warkins, I want to direct you to the document that is titled Qualification Criteria for Admittance to the AAA National Roster of Arbitrators. Do you see that document?
I do.
Okay, and is that a document that can be located on the website for the American Arbitration Association?
Yes.
Okay, and have you had an opportunity to review that document prior to your testimony right now?
Yes.
Okay, and Your Honor, I would go ahead and move to admit the qualification criteria as Defendant's Exhibit 3.
Mr. Monning, any objection?
Is that contained in the rules that are already admitted, Mr. Brady?
No, it's a separate document.
Okay, I have to go back and find that document. Just a minute here. No, that's not it. Bear with me.
That's okay. Mr. Monning, maybe I can help.
No, I've got it. It's come. Okay, there I've got the rules. Okay. Qualification criteria. Okay, I've got it. I object. That's irrelevant. Those are from the commercial rules.
All right, court's going to overrule the objection and admit defendants Exhibit 3, the qualification criteria for admittance to the AAA national roster of arbitrators. Go ahead,
Mr. Warkins, based upon your review of what's been admitted as Defendant's Exhibit 3, is there any requirement for an arbitrator to be an attorney at all?
No.
Is there any requirement that an arbitrator be a practicing attorney?
No.
Is there any requirement that says even if an arbitrator is a non-practicing attorney that he would be disqualified from serving as an arbitrator?
No, there is not.
Just the document speaks for itself, but just generally summarize what you see as the qualifications for someone to serve as an arbitrator in a dispute of this nature.
10 years or more experience in senior level business related or legal practice, some expertise in this field, experience, training, and then any other relevant publishings or awards that would give credence to you being a quote unquote expert in these types of matters.
And Mr. Warkins, as far as you know, was the arbitrator in this case, Mr. Hardcastle, a licensed Texas attorney?
Yes.
And that would be one thing that factors into whether one is qualified to be an arbitrator, correct?
Yes, that would go to point A of qualifications. It would check one of the requirements.
And point B as well regarding professional licenses, correct?
Correct.
Mr. Warkins, I want to talk about the arbitration proceeding itself now. first, let me ask you this. Was 21st Mortgage Corporation required to pay some amount of money in order for this arbitration to be initiated and, in fact, to be concluded?
Yes, we paid significant amounts of money in at least 3 different invoices.
And in the arbitration awards, it provides that part of the award was compensation of the arbitrator totaling $3,750. Are you aware of that?
Yes,
Okay, and did 21st Mortgage in fact pay thousands of dollars for this arbitration to proceed?
yes, well over $6,000 at a minimum.
Mr. Workins, you're aware from the applicant's evidence today that the American Arbitration Association did appoint attorney A. Hardcastle to serve as arbitrator, correct?
Correct.
And were you aware that the parties and legal counsel were given a right to object to his appointment within 5 business days?
Yes.
And do you know if anyone objected to Mr. Hardcastle serving as arbitrator in this case?
Nobody objected.
Mr. Workins, you're also aware that fairly early on that there was basically a scheduling conference with counsel and with the arbitrator, correct?
Correct.
Okay, and in fact, the arbitrator thereafter basically circulated a proposed scheduling order with various deadlines, right?
Yes.
And one of those deadlines was the right for 21st Mortgage Corporation to seek summary relief if it so chose, correct?
Correct.
Another one of those deadlines was for 21st Mortgage Corporation and the Dixons to submit a joint exhibit list if they could agree upon exhibits. Were you aware of that?
Yes.
Okay, and I want to direct your attention to documents attached to the motion for summary judgment filed in this case by 21st Mortgage Corporation, and they have numbers 187 through 188.
Is that page 187 through 188?
That's the number in the upper left corner.
Sure, okay.
I'm there.
I'm getting there.
Mr. Workins, is that?
Would you wait to let me find it? I'm scrolling down
Oh, I'm sorry.
to page 187.
Sorry, Prater, I thought you were there.
I'm at 179, just a minute. Okay, I'm at page 187.
Mr. Workins, is that a document that was submitted to the arbitrator as far as you know?
Yes.
And the exhibits that were referenced in the joint exhibit list were also provided to the arbitrator as far as you know. Is that correct?
Correct.
You know, I would move to admit, I guess I'll call it whatever the court wants me to call it, defendants 187 through 188 into evidence.
Any objection, Mr. Wine?
No objection to 187 to 188.
All right, court admits defendants 187, 188, which is the joint exhibit list before the American Arbitration Association.
Mr. Workins, did you travel from Knoxville, Tennessee to Canton, Texas to attend the arbitration on September 23 of 2019?
I traveled the day before and stayed the night near Canton and then commuted over the morning of the 23rd.
And Mr. Orkins, I want you to just basically, in your own words, describe in a narrative fashion what actually occurred, from the time you got to the office where the arbitration was to be conducted until you left.
I drove to the office and arrived right around 9 o'clock. I sat in the waiting room for 1 to 2 minutes. Was told by the reception that Miss Dixon and I believe Mr. Monning were already present in the conference room. Mr. Hardcastle came in 1 to 2 minutes after I arrived. We exchanged pleasantries in the lobby. I believe he went into the room and I waited on Mr. Brady. We went back to the room shortly after 9 and commenced. It was discussed that Mr. Hardcastle had learned of a family friend's death that morning. We then began the arbitration proceedings shortly after 9 o'clock. My recollection is Mr. Monning went first with, first off, pardon me, Your Honor, Mr. Brady discussed the summary judgment motion we had previously filed and re-urged consideration on that. A couple-minute discussion. We began the arbitration and Mr. Monning went for, I would say slightly more than 10 minutes. Mr. Brady went after. I think both parties have said that there can be a bit long-winded, and I think that was bore out after opening statements were made by both attorneys. There was some discussion about Mr. Hardcastle asked some questions. I can't remember the exact order if we first went into his ability to decide the title issue or if we discussed certain notices that were given in the case. Both foreclosure notice issued in the previous, during the life of the loan were discussed, as were notices issued in conjunction with the settlement agreement that was entered in the state court action. That was a several-minute discussion, including clarification on a letter Mr. Brady sent to informing Ms. Dixon about default in August and the amount. So we discussed that. Ms. Dixon did speak at that time, answered a few questions on that. I won't say many, but a few questions. At that point, we moved on to Mr. Hardcastle discussed issues that he wanted the attorneys to brief. He gave a list of 3 issues. We discussed a scheduling deadline in October. And at that point, the mediation was ended. Mr. Hardcastle left. Ms. Dixon, I believe, left shortly thereafter. And for the next 30 minutes, Mr. Brady, Mr. Monning, and myself discussed the case and some potential options we may have for resolution. To my recollection, I left the attorney's office at approximately 11:15 to 11:30. I know that because I was debating on trying to get back to Knoxville that night from Dallas and was seeing how much time, if I had time to visit with Sean and try to get to the DFW to catch a plane back, or if I was going to stay the night.
Mr. Workins, did the arbitrator ever say anything to the effect that these proceedings are suspended and will be resumed at a later date. Anything to that effect?
Not to my recollection, no.
Was it your opinion that the arbitrator, through asking questions of Mrs. Dixon, that he had gathered all evidence he felt he needed to make a final award in this case?
My opinion, yes, it was mostly legal arguments. The factual arguments or questions were very, very minor and addressed at that point.
And was anyone advised that they could not ask questions of Ms. Dixon? I'm sorry, Mr. Workins, did you answer?
No, nobody
Okay.
was advised, yes.
Okay, and do you recall who may have asked questions to Ms. Dixon?
Yourself, Mr. Hardcastle, and I know Mr. Monning spoke to Ms. Dixon and regarding a notice that was received.
And Mr. Workins, after arbitration was concluded, you then did what?
As I said, we visited with Mr. Monning for a little bit, and I spent the rest of the day in Dallas, returned to Knoxville the next day.
Okay, and Mr. Workins, you had mentioned that that the arbitrator had requested a briefing on a number of issues, correct?
Correct.
And did 21st Mortgage Corporation timely submit a post-arbitration brief?
Yes, you prepared, I reviewed, and we timely submitted it.
Okay, and I want to direct you again to the motion for summary judgment filed in this case, and in particular to pages 32 through 186.
Yes.
Would those pages represent the post-arbitration brief submitted to the arbitrator on behalf of 21st Mortgage Corporation?
Yes, they would.
Your Honor, I would move to admit defendants 32 through 186.
Bear with me just a minute. No objection.
All right, there being no objection, the court hereby admits defendants exhibits 32 through 186.
Mr. Workins, do you know if Mr. Monning submitted a post-arbitration brief on behalf of the Dixons?
Yes, he did. I believe it was entitled a letter, but yes.
Okay, so he submitted a letter brief, correct?
Yes.
Okay, and I want to refer you to the PDF delivered to the court that is titled 838. Dixon's post-arbitration brief dated October 14 of 2019. You see that document, sir?
Yes.
Okay, and as far as you know, is that the post-arbitration brief submitted to the arbitrator on behalf of the Dixons?
Yes.
Your Honor, I would move to offer defendants, I'll call that exhibit
4.
What's 3, Your Honor?
3 is the qualification the qualification criteria.
Yes, you're correct, then, Your Honor. Exhibit 4.
Any objection, Mr. Wanting?
Yes, Your Honor, that document is duplicative. It is already in evidence as applicant's exhibit number 13. It's the same document.
Do you withdraw the offer, Mr. Brady, or do you want the court to rule?
In the interest of moving this along, I don't know if it's as represented by Mr. Prater or not. I don't think there's anything preventing the court from admitting 2 exhibits that are the same.
All right, court hereby overrules the objection of duplicative, and the court admits defendant's exhibit 4. I believe that's the post-arbitration agreement submitted on behalf of Ms. Dixon.
Post-arbitration brief.
I'm sorry. All right, that's admitted into evidence.
And Mr. Warkins, did 21st Mortgage Corporation then submit basically a response to the post-arbitration brief of the Dixons?
Yes.
Okay, and I want to refer you to the PDF that was sent to the court. It's titled 838. Reply of 21st. No, hold on, I'm sorry. Title 838, reply of 21st Mortgage dated October 17, 2019 to Dixon's post-arbitration brief. Do you see that document?
Yes.
Okay, and is that the response that was submitted to the Dixon's post-arbitration brief?
Yes, it is.
Okay, and Your Honor, I would move to admit that as defendant's exhibit 5.
No objection.
Defendant's exhibit 5 is admitted into evidence.
So, Mr. Warkins, so that response was dated October 17, correct?
Yes.
Okay, and the actual arbitration award in this case was dated November 26 of 2019, right?
I believe that's correct.
Okay, so the arbitrator took, about 5 weeks to actually, go through all the evidence and material and actually issue an award, correct?
Correct.
Okay. And he had quite a bit to go through as the documents that have been admitted into evidence have shown, correct?
Correct.
Mr. Warkins, I want to direct your attention to again, to the motion for summary judgment filed by 21st Mortgage Corporation in this case, and specifically exhibit number, or specifically the document that has the number 30 in the upper left corner.
Okay.
And is that in fact a copy of the award of the arbitrator?
Yes.
Okay, and Your Honor, I would move to admit that as defendant's exhibit 6, please.
Objection, it's already in evidence as applicant's exhibit number 14.
Court overrules the objection, admits defendant's exhibit 6.
Mr. Warkins, is that award make certain findings?
Objection,
Yes.
the award, the document speaks for itself.
Well, Your Honor, I think one of the grounds asserted, or at least it's in their application, is that the arbitrator did not issue a reasoned award. So I think I'm allowed to ask questions of this witness.
My
It's gonna over-
objection stands,
court's
the
gonna-
document speaks for itself. This witness is not entitled to get into the mind of the arbitrator. The award speaks for itself.
I understand. Court's going to overrule the objection. The witness can read from the exhibit at the very least.
Can you repeat the question?
Yeah, were there certain findings made by the arbitrator in the award?
Yes.
And would those findings be found, among other places, in the third full paragraph of the award?
Correct.
And what, can you read that paragraph for the court, please?
Yes. I conclude that the settlement agreement entered into the parties in a lawsuit involving substantially the same issues as in this case is valid. Accordingly, I rule that the filing of the deed by respondent is valid and title to the property in question is vested in respondent.
Okay. Mr. Workins, would you agree that this represents, based upon your experience, a reasoned award?
Yes.
It wasn't simply a document saying I rule in favor of the Dixons or I rule in favor of 21st Mortgage Corporation, correct?
Correct.
Mr. Workins, after the arbitration award was signed, do you know if the Dixons requested the arbitration award to be corrected?
Yes, they did.
Okay, and again, I'm referring you back to the email delivered to the court in this case, and specifically to the PDF that is titled Reply of 21st Mortgage. I'm sorry. It's titled Dixon's Request for Correction of Arbitration Award dated December 13, 2019. Do you see that?
All right, I got a lot of papers and I might have got them a little muddled. I don't know if I have it in front of me, Sean. I think I've got it here, but it got muddled.
Well, let me ask you this way, Mr. Workers. Do you recall seeing a letter from Mr. Monning dated December 13 of 2010, where in the first paragraph, he was asking for the arbitration award to be corrected?
Yes, I have that here. Yes, I see it now, and yes.
Your Honor, I would move to admit the letter from Mr. Monning dated December 13 as Defendant's Exhibit 7.
Oh, to which email is it attached, Sean?
It's the one I sent to the court that I copied you on.
Okay, I'm looking for it. Let's see here.
It's dated June the 30th at 3:12 p.m.
Got to go to the bottom of the email. Somebody just sent it to me, then it went away again. And I know that I sent it, but I mean, is that my letter that I sent? My motion to correct? Is that what you're telling me?
You did it in a letter format.
Okay,
Well, hang on, no, that's not it.
okay. No, that's a letter from you.
Hang on.
Kurt, I'm talking about a letter from you dated December 13, 2019. Where
Well,
you're,
it may be easier for me just to go to my file and get a copy of the letter. I mean, just a minute here.
Try this again. So said, Mr.
Yes, I've got it. Yes, that is my letter to Mr. Hardcastle through the American Arbitration Association. Yes.
yeah, I can't recall if I moved to admit or not.
You did. You offered as defendants exhibit 7.
And did the court admit it?
No
Well, I was
objection.
waiting for Mr. Monty to have a chance to reply. Okay, he has no objection. Court hereby admits defendants exhibit 7.
And Mr. Warkins, did my office on behalf of 21st Mortgage Corporation respond to the request from Mr. Monning for the correction of the arbitration award?
Yes.
Okay, and I'm referring you to the email delivered to the court and specifically to the PDF titled Reply of 21st Mortgage dated December 18, the Dixon's request for correction of arbitration award. You see that document?
Yes.
Okay, and I would move to admit that document, Your Honor, into evidence as defendant's exhibit 8.
Judge, can you display that for me? It doesn't come up in what I've got.
I believe I can. Just one moment here.
Trader, do you want me to send you the email I sent before
Yeah.
again?
I've got the email that you sent me 46 minutes ago.
Well, now I'm talking about one dated
Is it
June
an
30,
early one?
June 30, which would have been yesterday at 3:12 p.m.
Okay, let me find that one.
Mr. Brady, what was the name of that document again?
It was a reply of 21st Mortgage dated December 18, 2019 to Dixon's request for correction of arbitration award.
I'll be able to display it here for you, Mr. Monty.
I think I'm getting to it.
And here we have it here.
Okay. Okay, no objection.
All right, then the court admits defendants exhibit 8, 21st mortgage reply to letter requesting correction.
Mr. Warkins, did the arbitrator in fact make a ruling on the Dixon's request for correction to the arbitration award?
Yes.
Okay, and I want to direct your attention again to the document emailed to the court titled Order of Arbitrator dated January 9, 2020, reaffirming arbitration award. Do you see that document?
Yes.
And Your Honor, I would move to admit that as defendant's exhibit 9.
And is this the document I'm displaying on the screen, Mr. Brady?
Yes, it is.
No objection.
All right, then there being no objection, the court admits defendants exhibit 9, the disposition of application for modification of award.
Mr. Warkins, let's look at that document for a minute, please.
Could I get it back up on the screen, Judge? There we go.
Can you read the first full paragraph for the court, please?
I, A. Hardcastle, the undersigned arbitrator, have
having been designated in accordance with the arbitration agreement entered into the above named parties and dated May 5th, 2005, and having been duly sworn and having duly heard the proofs and allegations of the parties during the evidentiary hearing held September 2019, and having previously rendered an award dated November 26, 2019, and claimant having filed an application for modification dated December 13, 2019, and respondent having responded on December 18, 2019, do hereby decide as follows.
Okay, and basically his decision is that the award is reaffirmed and remains in full force and effect, correct?
Correct.
And in that paragraph you just read, the arbitrator does make reference to an evidentiary hearing which took place, correct?
Yes.
And he does reference himself, the arbitrator, hearing what he calls proofs and allegations, correct?
Yes.
Mr. Warkins, after that request for relief was denied by the Dixons, is it your understanding that the Dixons filed this current proceeding in an effort to vacate the arbitration award?
Yes.
Okay, and you've seen that application, correct?
Yes.
Okay, and that application references the Texas Arbitration Act, does it not?
Correct.
Referring back to Defendant's Exhibit 31, which is actually the arbitration agreement that's already been admitted into evidence, does that agreement provide that the arbitration is to be controlled pursuant to the Federal Arbitration Act?
Yes, it does.
Mr. Workins, I want to refer you briefly to the application to vacate the arbitration award itself. Do you happen to have that with you, sir? It's a pleading filed in this case.
I don't know.
Well, in the interest of moving this along, I'll read from it and I'll represent that I'm accurately reading what it says. And the document speaks for itself, but I'm referring to page 5 of the application to vacate arbitration award, where the following allegations are made, and I'd like for you to comment on these allegations based upon your being physically present at the arbitration proceeding, okay?
Yes.
Okay, so on page 5 of the application, it's alleged that the arbitrator was not properly appointed. Would you agree with that allegation?
No.
Why not?
The arbitrator was properly appointed and each party's had a ample opportunity to object.
The next allegation is that the arbitrator misrepresented and failed to properly disclose his qualifications to serve. Do you agree with that allegation?
No.
And why is that?
I mean, he's duly appointed by the AAA. His resume was attached and both parties had ample opportunity to research his resume and history and object.
The next allegation, Mr. Warkins, is that the arbitrator failed to conduct a hearing in accordance with the rules of the arbitration forum. Do you agree with that allegation?
No.
And why is that?
Because I attended a hearing in Canton, Texas, and I believe that it complied with the rules and all parties were given their due process.
And once again, Mr. Warkins, the parties in this arbitration even contemplated that the arbitrator could award summary relief. Is that not correct?
Correct.
Okay, the next allegation is that the arbitrator failed to hear evidence. Do you agree with that allegation?
No, I do not.
And why is that?
Because I attended the arbitration in Canton, evidentiary issues were discussed and questions were asked. The arbitrator had at his disposal voluminous documents regarding the case, and each counsel, submitted agreed exhibits, and I believe he had full information.
All right, Mr. Warkins, and the next allegation is similar. So just tell me if the response you gave just now would be the same response to this allegation, which is that the arbitrator failed to afford the Dixons the right to present their case, to testify by direct examination, and to cross-examine witnesses. Would your answer be the same as to what you just testified as to the prior allegation?
Yes, it would.
And finally, Mr. Warkins, the last allegation on page 5 of the application is that the arbitrator failed to issue a reasoned award addressing the issues. Would you agree with that allegation?
No.
And why is that?
The award clearly spells out the rationale for his decision and clearly spells out the relief granted.
Mr. Warkins, in the event this court denies the application to vacate the arbitration award, is 21st Mortgage Corporation also requesting that this court, in fact, issue an order that confirms the arbitration award?
Yes.
I'll pass the witness, Your Honor.
Mr. Monning, any questions?
Yes, Judge. Well, we did clear up one thing, Mr. Warkins, and that is that this arbitration was not conducted under the commercial arbitration rules. It was conducted under the consumer arbitration rules, wasn't it?
I see that now, Mr.
Yeah.
Monning. Yes. In correspondence, including the January 19th disposition of application for modification of award. I do see that.
And the consumer arbitration rules are completely different rules, aren't they?
They are different rules. Completely may be an overstatement.
And in fact, the arbitrator even stated in his resume that he gave to the parties on May the 2nd of 2019 that he was going to be proceeding under the consumer arbitration rules, didn't he? Do you have Exhibit 9 with you?
I
Your
do.
arbitrator-
I have no reason to doubt what you're saying, though, Mr. Monning.
Judge, do you have Exhibit 9?
I do.
It's in tab 9. At the very end, it refers to the applicable consumer arbitration rules, doesn't it? Does it, Mr. Watkins?
I'm close to finding it.
Okay. You also included it as an exhibit to your affidavit.
Yes. Can you restate your or repeat your question, Mr. Monning?
Well,
I've got the document in front of me now.
Turn to the very last 3 words in his resume on page 2.
Yes, sir.
It's clear. It was the consumer arbitration rules, wasn't it?
I agree with that, as I previously said, yes.
Now, you also provided some testimony regarding the appointment of arbitrators under the commercial rules in reference to the National Register and his qualifications under the National Register. But what I'd like for you to do is turn to the applicant's exhibit number 10 in this case. It is the oath that the arbitrator provided.
I'm there.
Okay. And in the very first paragraph of it's called on page 1, General Arbitrator Oath Form. You have that in front of you?
Yes, sir.
It is very clear that, at least according to the American Arbitration Association, it was necessary that Mr. Hardcastle correct any misstatements in his resume, wasn't it?
Says, I attest that I have reviewed my biographical information provided to the parties and confirm it is current, accurate, and complete.
That's what he swore to on page 3. We agree, you agree with that? He swore
Yes,
that that was true, didn't he? Is that right?
he swore, can you repeat the question?
He attested that it was current, complete, and accurate, didn't he?
That what was?
His resume.
Well, this says biographical information, but he did swear to that, yes.
Okay. Now, what I asked you though was turn to page 1 of Exhibit 10.
Okay,
And these are the rules that the AAA gave him regarding his disclosure obligations, aren't they?
yes,
And what they said in the middle of the first paragraph, that he needed to correct anything in the biographical information that was incorrect.
can you point me to where you want me to look on that?
Right in it's the third sentence under disclosure obligations. Let me read it to you. This is a continuing obligation throughout your service on the case. And should any direct or indirect contact arise during the course of the arbitration, or if there is any change at any time in the biographical information you have provided, it must also be disclosed.
Yes, that's what it says, and I agree to that.
Yeah. Now, would it be fair to say, Mr. Watkins, when you received the notice of appointment by the American Arbitration Association with Mr. Hardcastle's oath and with Mr. Hardcastle's resume, you reviewed it?
Absolutely.
And also be fair to say that based upon your review of his oath and his resume, you concluded that he had a substantial and varied private law practice.
No, that would not be correct.
Okay.
I did not consider his law practice, I considered his experience.
You'd read the part where it said he had an extensive and varied practice, litigating family, probate, and general commercial cases in state or federal courts, general corporate and business practice for the last 21 years. You considered that, didn't you?
I considered his resume as a whole.
Okay. And be fair to say that you didn't see anything in the disclosures that he made that would have any basis for wanting to disqualify him.
Correct.
Now, let's go to September the 23rd. You will agree with me, will you not, that Mr. Hardcastle did tell the parties that he would not be able to finish on that day because he needed to return to Dallas?
Yeah, I'm going to object. Calls for hearsay.
I'm not offering it for truth, Your Honor. I'm offering it to show that it was said. He has already testified on this subject.
I'm going to overrule the objection. You can answer, Mr. Workins.
Can you repeat the question?
He told us at that hearing on the 23rd that a dear friend had died and he would not be able to finish on that day, didn't he?
He told us that a friend had passed and that the matter was concluded for the day. I don't believe he said he would not be able to finish, but
Okay,
I
but he
can't
said it
recall
was
his
concluded
exact
for the
words.
day.
Said it was, I don't recall his exact words.
Okay. Are you saying that was do you dispute Ms. Dixon's testimony, her recollection that he told the parties he would not be able to finish on that day?
I believe he told he would not be able to rule that day. And he gave legal issues for both counsel to brief. And I left there fully expecting never to come back to Canton for this matter.
Mr. Workin, have you participated in arbitration under the consumer arbitration rules?
Yes, I have.
And you know that those consumer arbitration rules do not provide for a ruling on the day of the hearing, do they?
I did not know that, but
Well, in fact, the rules provide for a decision in writing, a reasoned award in writing be delivered within 30 days following the hearing, don't they?
Yeah, I'm going to object unless these rules are in evidence or before the witness. But there's been no proper foundation laid for the witness to answer that question.
Have we admitted the rules of,
You admitted the commercial arbitration rules.
we've admitted the commercial arbitration rules, but not the consumer?
Yes.
All right, then I'm going to sustain the objection until they're provided to the witness.
Now, you will agree with me, and I think you testified to this, that Mr. Hardcastle discussed with the, I'm sorry, do you need something? No. Okay. He discussed some issues that he was concerned with, didn't he?
yes,
And you'll agree with me that those issues that he discussed were issues of law that he recognizes he needed to rule upon.
yes, I
Okay.
believe.
In one of those issues of law, he was wondering whether or not he even had the power to determine issues of legal title to Texas land, didn't he?
Correct.
And another issue was he was concerned with whether Ms. Dixon could have waived her right to notice of default.
Correct.
And he knew those were issues of law, didn't he?
I believe so, yes.
And you knew those were issues of law, didn't you?
Yes,
And both he and you knew that he needed to decide those issues of law.
he knew that he needed to decide them, and I believe they were issues of law, yes.
Now, at this hearing on September the 23rd, I did not examine you, did I?
No, correct.
You did not testify at all, did you?
I did not.
I did not rest my case, did I?
I do not recall you resting your case.
Okay. You did not rest your case, did you?
Correct. We did not.
I did not give closing argument, did I?
There was no formal closing argument by you, correct?
Your lawyer did not provide closing argument, did he?
No, he did not.
Now, but it's your testimony that he nevertheless ruled by considering the evidence that was before him. Is that right?
Yes, sir.
And that evidence included your affidavit, didn't it?
Yes.
Was I given an opportunity to cross-examine you on statements that you made in your affidavit?
You were not denied an opportunity to cross-examine me.
Well, you didn't even take the witness stand, did you?
We were sitting around a table. There was no stand, and
Let's turn to your affidavit. Let's turn to Exhibit 21.
Okay.
That is your affidavit, is it not?
Yes, sir.
And that is your signature on it, isn't it?
Yes, it is.
And you swore that that was true, didn't you?
Yes, I did.
We'll offer Exhibit 21.
Where is this, Prater? I'm trying to find it.
Exhibit 21.
Oh,
My
from your,
exhibit.
from your list?
Yes. It's also included, actually, you've already introduced it into evidence as your exhibit respondents 165 through 67.
All right, no objection.
Okay.
All right, then the court's going to admit again the affidavit of Jeff Orkins as petitioner's exhibit. Did you label that, Mr. Monning?
It's Exhibit 21. It's in your binder. It's Exhibit 21.
21, all right. Then, or I'm sorry, applicants or plaintiff's exhibit 21 is admitted in evidence.
Okay. Would you turn to page 2 of your exhibit?
Yes, sir.
You state beginning in the sentence that ends at the bottom of page 2, you state, after all parties signed the release agreements, the Dixons began making their catch-up payments. But as of August 13, 2018, the defendants defaulted in their obligation to pay these catch-up payments.
Correct.
Your
That's
Honor, again, I'm going to object. I think he's getting again into the underlying merits of the case. Yeah, I think we're allowed to present this evidence to the court to show what information and what evidence the arbitrator had to make a ruling. But as far as the substantive evidence, or excuse me, I'm sorry, as far as the substantive merits or arguments that resulted in that decision, I think are not relevant.
All right. Court's going to overrule your objection. You can answer.
That's what you said in your affidavit, isn't it?
That's what I signed to, yes.
Yes. What I'd like for you to do is turn to applicant's exhibit number 4. And Your Honor, you previously had sustained an objection to applicant's exhibit number 4. It has now been admitted into evidence as part of the respondent's exhibit number
160.
160, whatever it is. He offered it into evidence. And I would re-offer exhibit 4.
All right, then the court hereby admits applicant's exhibit 4 in evidence.
Okay. Now,
I'm there.
that's a letter from your lawyer.
Yes, sir.
In that letter, your lawyer, in the 3rd paragraph, he states, and that is as of August 3, 2018, he says currently the account is due and owing the sum of $380.90. Is that right?
Correct.
And he gave her 10 days to make that payment, didn't he?
Yes.
In the next sentence. Would you turn to page 2 of your lawyer's letter to Ms. Dixon?
Okay.
Did he tell Ms. Dixon, and I'm reading there, if the default is cured by tendering $380.90 within, then regular payments continue in accordance with.
Hang on, Mr. Monning. Mr. Monning, I'm going to ask you to, Mr. Monning, I'm sorry. There's a lot of noise on this side. I'm going to ask you to repeat your question to Mr. Brady. I'm sorry to the witness.
Okay.
I was questioning him about the first sentence on page 2 of his, Mr. Brady's letter, reference applicant's exhibit 4. And I'm sorry, we couldn't hear on this side. court reporter cannot take down a record.
And what it says is if the default is cured by tendering $380.90, then regular payments may continue in accordance with the forbearance agreement and mutual release and the contract. That's what he said, isn't it?
Correct.
And will you agree with me, Mr. Warkins, that Ms. Dixon paid that $380.90?
Yes, I will.
And she paid that money prior to August the 13th, 2018, didn't it?
The funds were received on August 13th, yes.
Funds were actually received on August the 10th, weren't they?
They were not. They were sent on August the 10th. After hours, they were received on August 13th and posted that day.
They were sent by MoneyGram, were they not?
They were.
And when you receive money by MoneyGram, that money is credited to your account on the day the MoneyGram completes, isn't it?
That is not correct. If it's received, if it's sent by a certain time, it is posted that day. And if it's not, it is posted the next business day.
So when you stated, you're saying you didn't get the money when she wire transferred it to you.
No, I'm not stating that. I can answer where you're going very quickly if you'd like me to.
No, I think the judge understands. What you're saying is, even though the money hit your bank account, you didn't account for it until later.
No, I'm not saying that at all, Mr. Monning. Please do not put words in my mouth. The funds were credited on August 13th, and the default that Mr. Brady's letter spoke of was cured. My affidavit contains a typo stating August 13th in default. It was supposed to be August 16th. I apologize that I did not catch that and sign that. The affidavit is talking about the catch-up payments, which were due the 15th of each month. So it's referring to the August 15th catch-up payment of $500 that Ms. Dixon did not send timely.
Okay. So you're saying, are you telling me that Mr. Brady's letter didn't relate to the catch-up payment?
Absolutely.
Okay. It related only to the regular mortgage payment. Is that what you're saying?
Yes, sir. And this was, and you know that's correct because you were at the arbitration where this was discussed.
Mr. Warkin, go back to your lawyer's letter, Exhibit 3. Pardon me, Exhibit 4.
Okay.
That letter did not complain of failure to make the mortgage payment in a timely fashion, did it?
Are you referring to the August 3rd letter?
Yeah, the August 3rd letter from your lawyer where he admits what she had made.
And the question is, can you repeat that, please?
The very last clause in paragraph 2 of your own lawyer's letter, does he not acknowledge that she had made her August mortgage payment in the sum of $513.06 on July 16th? That's what it says, doesn't it?
Does not say that made the August payment.
Well, I'm sorry, did I say August? It says 7 payments received on July 16th in the sum of $513. That was received, wasn't it?
Yes, sir.
So that letter didn't complain about failure to make a mortgage payment, did it? She'd made her mortgage payment. They were all current, weren't they, Mr. Warkins?
Very simply, Ms. Dixon was current with her monthly payments under the forbearance agreement as of August 13th. She was not, as of August 16th, she did not make the catch-up payment that was contemplated on August 15th.
And
Very
you're
simple.
saying that the affidavit then that you signed was just a typo.
Yes, sir. And the forbearance agreement and the payment history speak for themselves on when the funds were due and when they were received.
Okay. It was just a typo on your part,
Yes, sir.
but it was a typo that was the only testimony that you gave that was available to Mr. Hardcastle, because you never testified live, did you?
I was not asked to testify live by either party.
And if you had testified live, I would have been able to point out at that hearing this, what you're calling a typo, that in fact she had received notice of default, that she had cured that default, and that your own lawyer told her that her loan would be reinstated. I was not permitted to do that, was I?
As I stated before, you were not denied to do that. You did not call me as a witness. You did not ask. But the matter was discussed because Ms. Dixon referenced that she never received a notice of default. She said she only received a letter that said she owed $380.90. And we all discussed, and this is probably the only time I spoke in the arbitration, was that the notice of default and the letter Ms. Dixon was received were one and the same. And that was timely cured, and we were not here, that the default, the recording of the deed was not because Ms. Dixon did not cure this default on that letter. It was because she did not make the $500 catch-up payment, and per the terms of the agreement, no notice was needed to give to her, no notice of default or any type of notice. That led to the discussion between Mr. Hardcastle, Mr. Brady, and yourself on the difference between the required foreclosure notices that were sent under Texas law that started the foreclosure and required notices under the settlement agreement that were properly issued.
Now, let's see if that was a typo or not. Would you turn to another affidavit that you filed? It's an affidavit you gave to Judge Martin last month. That's exhibit number 22.
Correct.
We'll offer exhibit 22, Your Honor.
Your Honor, again, I'm going to object. Mr. Workins has explained himself, and now Mr. Monty wants to get into pleadings in another case. And really, the issues before this court are what happened at arbitration. Mr. Workins has explained his position concisely, so it's not relevant.
If it pleases the court, exhibit 22 has already been offered into evidence by the respondent and admitted into evidence. It's pages 191 through 196 of the motion for summary judgment that has been admitted into evidence.
So would you rather just refer the witness to their own exhibit 191?
No, I want to offer it as my own exhibit.
Okay, this is getting rather fun. All right, the court hereby admits applicants exhibit, what number are we on, Mr.? Is it number 22?
Is exhibit 22.
At some point, the court would really appreciate not admitting the same exhibits over and over and just refer to them and move on. My next case is here, and we've got about 4 minutes left.
Well, Judge, that was my point, but we've admitted a bunch of exhibits. That, well,
I'll tell you what we're gonna do. I'm gonna take a recess in this case and speak with counsel on my next case. So I'm gonna put all of you in the waiting room, and I'll be back with you in just a moment.
thank you.